Good evening, everyone. I would like to extend a warm welcome to all of you attending Afsa HKA Ciarb South Africa branch workshop today. We are grateful for your presence and excited to engage in each of you as we explore the important topic of our agenda. But before we dive into our discussion, I would like to take a moment to honor the memory of our estimate Afsa Vice Chairman, Advocate Patrick Lane, AC, who recently passed away. His leadership and vision were instrumental in shaping our organization, and his contribution will be deeply missed. In respect of his memory, I invite you all to join me in a moment of silence. Thank you. Let us carry his spirit and dedication with us as we proceed with today's workshop. Once again, welcome, and we look forward to our fruitful discussion ahead. Igor, the floor is yours.
Thank you, Svetlana. Well, good evening, everyone, and many thanks for joining us today, both in person, and I understand we have colleagues joining online. My brilliant co-speakers and I indeed hope that you will find this session helpful, refreshing, and entertaining. We learned that the people learn best when they're having fun. So basically, you should be having fun tonight. We're going to be having a difficult topic, but I discussed this with Henk that it needs to be with a light touch, right? So feel welcome to ask very difficult questions, first to Team, then to Andre, and then Duncan as an arbitrator, right? So that's basically how this is going to go. But before we start, I'm beyond grateful for joint organizing efforts of Afsa, Ciarb, and HKA for making this event happen. So could we have one round of applause for the organizing team, please? Many thanks. So my name is Igor Ciarb, and I'm a principal and a quantum expert based in HK's Dubai office, and I will be your host and a moderator for this evening. Our topic is, as you can see on the screen, how to get the most effective evidence from your independent expert witness. I think the overwhelming interest into this event best describes how relevant the topic is. But to demonstrate that there is a real issue with the effectiveness of the expert evidence, and by way of the example, the RICS has issued a practice statement earlier this year to its members, acting as expert witnesses to remind them that they're overriding duties to the tribunal and not to the party instructing them. Similarly, many organizations like the SCL, the RBF, and indeed the Ciarb have organized events across the globe to discuss this, and I'm beyond thrilled that we will be discussing this topic in Johannesburg this evening. So whose fault is it that the expert evidence is not effective? So I'm basically happy to introduce you to the three high-profile suspects who will share their views from the perspectives of the arbitrator, counsel, and expert, convincing you that it's not their fault, but rather that the other two are to be blamed. And now I will try to do the impossible by operating these slides, but if it doesn't work, then we have Mr. Garrett as a plan B. Right. So let's start with the arbitrator first. And this evening, the views of the arbitrators will be shared by Duncan Turner, SE from Advocates Group 621. First, I'm going to tell you everything that you already know about Duncan, and then I'm going to ask him to tell you something that you do not know about him. So Duncan is a practicing advocate at the Johannesburg Bar. He acts as counsel and sits as an arbitrator in disputes involving various industries, including construction and engineering. He's also a mediator and chairs the mediation division of Afsa. So Duncan, we have a deal, right? So you're going to share a funny but yet educational moment from your career when you were a junior, or perhaps not so junior. So the choice is yours.
Good evening, everyone. I started life as an attorney, and as a young attorney, I had the benefit of exposure to a fascinating practice. When the Ciarb Bridge fell over, it was my first year of articles in 1998. I've seen engineering disputes in the North Sea where the Norwegians were fighting with the Singaporeans. I've had a fascinating run at a number of different types of engineering and construction disputes, including the Gautrain and Kusile, etc. But as a lawyer, I want to share. It's not actually a funny story, but it's something that I just want to remind you about the role we play and the importance of the system, the dispute resolution system we have, and to remind us that we are dispute resolution practitioners first. And in doing that, we're looking to resolve disputes. And as a young practitioner, I was briefed, as a young attorney, I was briefed for an Englishman who was building a 1,200 square meter dream house down in White River. And he was building it by remote control. He'd appointed a local engineer, architect, and builder. And what happened, what he didn't know is they were in cahoots. And when he arrived in his magnificent property that looked good to the eye, he spent the first summer with the water coming down the road, down the driveway, and through the front door. And he appointed an expert, well-known, renowned expert, to come and tell him how to take this thing forward. And the expert arrived before the lawyers, before anyone else, and gave him a list of 500 defects in the house. And over the next 4 years, the chap was fighting in the legal system, and he had all the problems that we know about, the delays. But he had to wake up in that house every day and see that the step was 3 centimeters too short and the balustrade was 5 centimeters too long and the damp-proof course wasn't in the right place. And he ended up actually having a mental breakdown and leaving. And so I just a poignant start to remember that, and it's something that stuck with me. It's one of the reasons why I'm a big mediation fan, as strange as it may be. But I thought I'd share that story just to remind us that dispute resolution is what we're about, and we're trying to get to resolve the dispute.
Thank you, Duncan. That was brief and funny. So let's move on. The interest of the councils in international arbitration. Did I push too far? I did a bit, yeah. Okay. Sorry, Duncan. But we need to relax. Meaning, I discussed this precise topic with Andre, so we'll see how he goes. So the interests of the council's international arbitration proceedings will be protected by Andre Gauci, SC, also from Advocates Group 621. So I understand that Andre is both Duncan's colleague and a competitor, right? So Andre has practiced as an advocate at the Johannesburg Bar for more than 40 years, 28 years as Silk. He now concentrates almost exclusively on acting as arbitrator, adjudicator, mediator, and the like, with a particular focus on engineering and construction matters. Andre is a fellow of the Ciarb, an Association of Arbitrators of South Africa. So, Andre, your turn, please.
I was asked by Igor to relate a story from my junior days, but I can't remember that far back, unfortunately. So what I do remember is my most recent case. Duncan was my arbitrator. My opponent is in the room. And there was an expert, a Frenchman. It was a Spanish company on the other side, and there were Spanish interpreters, and the French engineer was their main expert, giving evidence in French and being translated for me and for the arbitrator. And he was completely unplayable. He would give to any question, no matter how direct and pointed I tried to make the question, he would just ramble on and give a lecture. And more than once, Duncan pulled him up and warned him to answer the questions, and he couldn't. It was just, that was his personality. He was just unplayable. In the end, Duncan said in his award that this witness had put himself beyond the reach of the cross-examiner. which is completely true. It was beyond my reach, and it was just an experience which I had to wait 40 years for that experience, but that was when I had it.
Thank you, Andre, and I think we're going to give credit to Duncan as well, right, for this. I think it's fair. Yes. And last but not the least, we have my HK colleague, Tim Having, acting as the expert. So Tim is a testifying expert in the field of delays on construction engineering projects, predominantly in South Africa. He comes from a civil engineering background and is currently appointed to give expert opinion on a number of building and engineering projects. So Tim, please enlighten us which moment has shaped your entry into the world of construction.
I'm not sure if it's funny, but it was certainly embarrassing, let's say. Can you hear me okay from back here? Yep. When I was a student engineer and I on a summer break and got my first engineering job, let's say, I was very excited and it was a highway project just outside Sydney. And I went to the project and I got everything I thought I needed, my calculator and my boots and my tape measure, and was very excited to help build something with concrete and do some engineering. And my first job on the first role on the project was to go and count all the trees. So it was a 10-kilometre highway. And I spent the first 3 weeks of my engineering career walking up and down, counting old trees and new trees and tall trees and short trees. 10 kilometres this direction and then 10 kilometres back. And all the while, the guys and the diggers and the workers and operators were giving me, heckling me. And so it's quite humbling. You think you're going to come in and start running a project and you start right at the bottom of the food chain as an engineer. So yeah, that was the beginning. And yeah, I still find the career quite humbling these days as well. So yeah.
Excellent. Thank you, Tim. So as you can imagine, this will be no ordinary event where you just sit and listen, right? And instead we will be seeking your engagement. And we will be doing this by way of the Mentimeter software, which, as you can see, I will try to operate through my phone, right? So on this slide, not this slide, the next slide, right? On this slide, you basically see two options how to connect. You can basically use your phone, laptop, tablet, whatever makes you happy, and you go to menti.com and then you enter the code. The easiest way of doing it is that you simply scan the QR code and it shall does it magic and connect you to the platform, if you like. And please do not panic. The website reference and the code will appear on all slides so that you have the information ready if you get disconnected at any point in time. I will now test from the audience if they manage to connect. So for example, Tabiso, we have everything in place, connected. All right, Henk. Oh, let's do it now, rock and roll. So we're starting. And now you will be pleased that the panel will not participate in this one, so it's purely yours. So who is in the audience, and that in the context of arbitration, primary profession? Why we are asking the questions? So that Andre, Duncan, and team kind of fine-tune the answers. We are offering, is it 1, 2, 3, 4, 5 or 6 options, being the party to a dispute, lawyer, counsel, arbitrator, expert, claims consultant, and the most popular option, other. Maybe Gareth, when we reach kind of 40, we can move on. You can tell me. I think sufficient number of people connected and voted. And it seems, Andre, that you've got a huge problem. Meaning the figures make it clear. Okay, so we're all good. And it seems, Duncan and team, you've got no pressure. You can just come clean and today, just be honest. Whereas Andre needs to kind of play around how this is going to appear. You think? They want to hear this now from you? Let's see. Okay. Let's move on then to the first question. So how this is going to work, we're going to be asking the question, and then the audience will vote or provide answers, and then each of the participants will say his thoughts about the topic. So I will really urge you to read the question carefully, so that experts have to be independent and expert, which is basically a given. But please emphasize one other quality that you think experts should possess. So this is basically a word cloud type of inquiry. So be careful that whatever you type, it will appear on the screen. So Sanjay, you can put the glass down and you can just simply vote. Tim, I think we have a already good number of answers. The answers are still coming, but I think you can start first, please.
Yeah, I think my answer's not up there, so nope, definitely not. So what I think is the number one quality outside, of course, independence and honesty and integrity and being an expert and having experience. I think the number one quality you need is really, really thick skin and a real ability to survive in really uncomfortable situations. Like I'm talking backpacking on a night train through China with people sitting on your lap, no idea where you're going, sort of uncomfortable. Like it's really, you're sitting in a room and you have to somehow think clearly when you have got one side of the room who all they want to do is see you crumble and start to mix your words and contradict yourself. And then you've got the other half of the room who they're the ones paying your fees. They're the ones that sort of, their case is quasi riding on every word that you say. So I think in amongst all that, you have to have the ability to sort of keep a clear mind and thick skin and when you're going to get prickly questions. And if you can do that, then I think an expert's obviously, usually going to not take too much, let's say, damage to their written report. And I think you'll do a good job and assist the tribunal.
Excellent. Thank you, Tim. I think, Andre, it's your turn.
To me, the one quality that I want from my expert is that he or she must be articulate. It is no good to have all the knowledge, all the expertise, flawless logic, and you can't convey it to what is often a layperson, but you must assume there's a layperson. So I say that you've got to be able to, my expert must be able to explain difficult concepts in very simple language that the arbitrator can understand. And I like to think of the example of Bill Bryson. You probably all have heard of him as an author. Short history of nearly everything. He explains the most complicated chemical engineering, astronomical concepts in simple language that you can understand. And you wish you could remember, but you can't remember. I couldn't remember, but certainly articulate is what I want.
Thank you, Andre. Great point. And Duncan, please.
I would say focus. Particularly from the position of an arbitrator, you want an expert to be focused, to know what the question is, what the answer is that they're giving to that question, and to make sure that they're not waffling and spending time exploring things that are not relevant to answering the particular question.
Excellent. As you can imagine, it seems that all of them provided correct answers, like probably most of the audience. This is probably my favorite questions, and this is where I cheat. So I'm going to say something, and I'm going to give them another go at the question. In my view, is basically these days, and it's something that probably Duncan will not experience as an arbitrator, but there can be a knock-on effect. This is the availability of experts. And I think it is equally said for arbitrators, to be honest, not to overcommit. At least in our practice, and this is the basic requirement that RICS sets out, basically for a professional surveyor. And we constantly see people failing this basic professional requirement. If the experts are not available, you cannot discuss the issues with the opposing number. Everything becomes protracted, and basically you are rushed, and your evidence, basically the evidence is ineffective, which is basically our topic for the evening. Tim, do you maybe want to add, comment, or maybe you can provide another quality that you believe that the experts shall possess?
No, I think that's a very good point. I think that if I think back in my own experience in my appointments, the best, and I think to use the word most effective, that my opinion's been, is when I've really had that time to dedicate to the initial reports, the engagements with the opposing expert, and then preparing for giving oral evidence. And so I do think that availability and that's is a key point. So trying to find not overcommitting, and also if you are taking on, no matter how much experience you have, you might have 40 years experience, and taking on your first expert appointment. So you want to have time to really to do that, and not say yes to every opportunity that comes your way necessarily.
Thank you, Tim. And Andre, how do you feel when you instruct an expert and you end up working with his number two?
Yes, it certainly is very irritating if your expert is not available. If there is no availability or limited availability, tell me upfront. I want to know upfront that you've got a problem, that you've got limited availability, then we can look at something else, or say it's not a problem, we can get extensions of time. But be straight with me and tell me upfront that you've got a problem with time.
Excellent. Duncan, perhaps something to add?
I would give it sort of a little bit of a segue to that, and that is that particularly for those experts who work in consultancies and give expert evidence so routinely. You get experts who come out of industry and they would pop into expert evidence, but there are, like HKA, organizations that have that are people are sort of career expert witnesses, and I would recommend that the team is a very important component. So I wouldn't emphasize the individual. Individual is, of course, critical when the witness is to be giving evidence, but you need that team, because if the expert, Tim's the front man, is giving evidence in 5 arbitrations, can't do all the work by himself. And so you've got to make sure you've got a good and well involved team. Don't keep your team in the back room.
Excellent. Thank you so much, Duncan. Just in the interest of clarity, we did not discuss this answer before Duncan entered the room, but thank you so much. Now we're gonna move on to the easiest question tonight, right? Meaning you're gonna know the answer. Yeah, but look, provide the honest answer. Don't provide the answer that you think it's correct. And that is, when should you instruct an expert? And now the difficulty is that I can't read the options, but I think you can read it on your phones. So that is, I think, before making a claim, when the issue are known, crystallized, and then we are moving on to the dispute resolution phase, before submissions, past submissions, and after all submissions and evidence, by that we mean factual evidence has been exchanged. Tim, can you read to there, or
Yeah,
you're struggling same way?
So the blue is for making a claim. The pink is when the issues have crystallized. Red is
Solution.
yeah. in dispute before submissions, that's right. Then there's one lone soldier who's voted for the final one there.
After all submissions and evidence has been exchanged. You see what the problem we have now? It's all anonymous. We don't know who that person is. So meaning actually now she needs to come clean, but we'll come to that. Right, Andre, I think this is probably your topic. I think you're in the driving seat for when you're instructing an expert. So perhaps if you can comment on the vote. You can start with this person.
Yes.
Yeah.
Look, when as counsel, I would like my expert on board at the earliest opportunity. The moment I know there's a claim coming, because the last thing I want is to have submitted a claim or have my client submit a claim and then find that the expert says, I don't agree with what you put in. So at the earliest opportunity, it gives, there are a few advantages. The one is you can get to your expert before your opponent does. So you have the choice of expert. You get a head start because we were talking about availability just now. The experts and the good experts are busy. And if you've got a head start and can start working on the matter, that is so much the better. And then the claim, the expert must help to formulate the claim properly so that it can be held down later. Not take my claim and try and justify it. Take my client's claim and try and justify it. So I say at the earliest opportunity, I have great support there.
Thank you, Andre. So Tim, now given that Andre has done the sales pitch for meaning us, now it's your turn.
Yeah, I mean, it's hard to disagree. The only thing I would add is that if you are the respondent, sometimes you don't know how the claim's going to be formulated and what experts you're going to need. So exactly, so you might be entering into a dispute, depending on how the submissions are made and the pleadings, you might not exactly know, and you might also be midway through the dispute and you start to understand that a certain factual or technical issue is going to turn the dispute, which might not necessarily be delay or quantum. It could be some niche technical expert that you're going to really need to support a position. So it's hard to instruct that person you don't know yet at the beginning.
Excellent. Thank you, Tim. And Duncan?
I'm going to throw a spanner in the works. Particularly from an arbitrator's point of view, the practice around the world is different. So there are different jurisdictions that deal with this differently. And certainly to solve Andre's problem, he needs expert assistance to prepare his claim. That person doesn't necessarily have to be the witness that gives evidence at the end of the proceedings. And in many jurisdictions, particularly in disputes that are large and complex, teams have two experts. They have the professor leading expert who sits in the wings, is reserved but not involved until the claim has been formulated, the evidence has been prepared, etc., and then is presented in a sort of uninvolved way to allow to express an opinion for the benefit of the tribunal. The individual who's been involved from the very beginning necessarily compromises their independence. It's just an unavoidable factor. So in small matters and in small jurisdictions, we've got to live with it. And so it's a practical question, a cost-effective question. But if you are going to run a high-stakes, high-value arbitration, book your professor for the hearing and get the junior professor in your team helping you to put the claim together. So it's a hybrid answer.
Duncan, thank you for these thoughts. So what do you as an arbitrator think when there is a claims consultant then acting as an expert witness? Will you be then considering his evidence basically on the quality of the report, or you will be basically you will put some prejudice to that, meaning that he produced or she produced the original claim?
I think we've got to be jurisdiction specific here. And if we're in South Africa, the way in which we do it is the same person is involved. And so we accept the report knowing that it has some of the defects that come with these things. But it has the practical, we live in the practical reality that that's how it had to be done. And so you are going to be testing the logic and the substance, and but if the facts have been properly recorded and the logic is there and the science is behind it, well, then it's an acceptable report.
I fully agree. And I'll support it with anecdotal evidence, meaning I know of a case, and I'll not mention a company, where meaning it was discovered that the expert was a claims consultant, and then obviously the lawyers on one side were celebrating through the night, right? And then the reality is that pretty much he was doing both delay and quantum. And basically on delay, he's done a great job. His evidence was accepted 100%. On quantum, he did a poor job. It was completely dismissed. So the tribunal in that case basically regarded this point that it was a claims consultant as pretty much zero, like a moot point. They simply judged it on the quality of work that him and his team have provided. Andrew, have you maybe had experience in such circumstances?
I fully subscribe to that. To me, the independence of the true independence of the expert is of less importance than the content of the evidence and the content of the report. I recently had a matter where there's no outside expert I could use. The people who know the industry of this cable manufacturing industry are inside the factory. And then it's not a case, I can't get an independent expert, but I must look at the quality of the evidence. The quality is there. It doesn't matter if the person is not entirely independent. So I agree with those points.
Tim, maybe you want to add something, or does it concur with your experience?
Yeah, I mean, I don't have too much experience where I've felt like the arbitrator's taken a view on that point. Obviously, it's something I've always been very conscious of, and we're always very quick to point out the other side's expert might be, say, dirty, be involved a bit too early in the proceedings. But then when you get to the hearing, somehow that gets lost, and the arbitrator generally wants to get to the answer and looking for some person or some evidence that's going to help him get there, and so him or her. And so yeah, ultimately it's few and far between where I've actually seen it being a feature.
Thank you. And I mean, I'll come clean, meaning this is the 5th time that we're running similar topics. And then Duncan, basically, when we discuss, for example, with English barristers, so their short answer is they will not go into that appointing the claims consultant unless they really need to. So that basically down to Andre's point. If you've got a person who will be capable of distance him herself from being subjective, it seems that the arbitrators are keen to judge on the quality of the evidence given to them and not being just simply constrained, well, he's the employee of a company or he's a claims consultant. Yeah. Okay, thank you very much. I think we digest the topic, and now you will be pleased that you can actually relax and enjoy, because the next one is purely for the panel. And then again, the detailed question is, what can you do as a counsel, expert arbitrator to ensure that expert evidence submitted to the tribunal is helpful, complete, expected? So it is quite broad. Feel welcome to mention more than one thing that you believe that you can do. And then I see that Andrew is looking at his notes, so he's well prepared to start first. Please.
Just that the memory is not always there, you know? From my point of view as counsel, I want to know in advance and have input into the expert's report. There's a difference between telling the expert what he must say, he or she must say, and testing what the expert says. It's the second that I'm on to. But first of all, I would look at the report before it goes to the other side, look at the report and say, has the expert answered the right questions? Is it focused on what we need to address? Is it complete? I must test the logic. Is the logic there? And I will cross-examine that expert as best as I could to try and replicate what will happen in the hearing. To test the logic, to see if it withstands scrutiny, and also to look at the report. Is it clear enough? Is it articulate enough? Does it explain things in a way that the reader will understand? So from my point of view, as counsel, to make sure the expert evidence is at its best, I want to make sure that that report will withstand scrutiny in the hearing.
Excellent. Thank you, Andre. Tim, I think it's your turn. What can you as an expert do?
Yeah, I mean, I have a quite boring answer to this, let's say, but I think it's actually quite important, and it's a general housekeeping point around referencing, organizing your report, structuring the report, and almost every sentence in the report is either a statement of fact, or it's a part of your analysis, or it's an assumption, or it's an opinion. And almost each of those sentences warrants a footnote, let's say. So if you're saying this is a fact, then you've got that from a document. And so you can pop that into a document. If it's your opinion, it's based on either a section of your report or an analysis maybe that's contained to your report. So that often under time pressures, you start to skip that step, but I think it's really important. And then that allows the other expert to understand how you're getting to your ultimate opinion. And then you usually go into a joint process, and you're both coming with an informed position. So if you receive an unreferenced report from the opposing expert, and you're sitting there thinking, how's he got this? How's he saying that? On what basis? Then how can you really have it go into a session or a joint meeting and make that and move the process forward, and ultimately give a product that helps the tribunal. So that's boring, but I think it really is an important step.
Basically, differentiation between the opinion and fact, which some people sometimes convolute. Thank you. And Duncan, please.
So I think my answer is a slightly hybrid between life as counsel and life as arbitrator. But I think to for an expert to be effective, you need to spend more time on the question than you think you do. I think people often talk about issues. What are the issues? And the expert's going to talk on these issues. But if you spend time deciding what that issue is, and you ask the room of the expert, the lawyer, the counsel, they'll all have a different, vaguer definition of what the issue is. And I think that both parties and the arbitrator, if the arbitrator is involved in a more interventionist style arbitration, at an early stage, gets a clear list of questions. Because if you spend more time on the questions, the answers actually come far easier. And the other thing it does is it allows alignment at an expert meeting. So the benefit to an arbitrator when the arbitration finally happens is that the questions to be answered by the arbitrator with the assistance of the expert are clearly defined, and you've got an alignment of what expert A and expert B say, so that you can compare them and decide which one is right. But if they're both formulated questions in different terms, they've answered them in different terms, and they're very difficult to align and very, very difficult to decide. So that I would suggest more rigor in identifying the question and formulating.
Thank you, Duncan. I really like your answer, but you stole my thunder. That was first thing that I now wanted to say. I really think the main point is that the experts to produce, as you rightly said, as early as possible, succinctly enumerated list of issues that they are dealing with and why they agree, why they disagree. Because sometimes, and I'll put him on the spot, you've got delay experts with 800 pages of paper. And when you ask them, what's the issue? Well, if you turn to the page 658 and then, at the paragraph 6.3.2.1, it's there, all right? If you don't put that into a Scott schedule, I admire you then, Duncan. How on earth you can make sense of what are they disputing? And again, I agree with Tim. Is it the fact that they are disputing, or it is an opinion that they are disputing? Because obviously then if it is a different fact is not for them. It's for someone else. And probably, Tim, if you want to chip in, agreement on the common data set, what we normally see, meaning parties, and obviously, Andre, we will appreciate parties can dispute the facts, yeah? But then if you've got 5,000 disputed facts and you give it to Tim and his counterpart, what is the delay analysis that you will receive? Can I get maybe your thoughts from your practical experience, how that works?
Yeah, you mean in terms of early engagements and agreement on data sets and for trying to reach early agreements? Yeah, I couldn't agree more that the earlier the better, to at least get some common starting point for both of the opposing experts. So at least they start from the same point, and maybe they head in slightly different directions, but at least they've at one point in time been in the same position with the same data set. And yeah, so I think as early as possible. This often seems to be a reluctance to do that, and I guess in the spirit of defending the experts, let's throw it over to the advocates. Why might you not get the experts involved? I mean, your answer was get them involved as soon as possible. I'm gathering, but why do you think that sometimes instructing attorneys or counsel don't sort of work that into the timetable?
Well, let me perhaps go there. The question that you have to, the issues that you have to determine are, firstly, before the matter starts, are a bit of guesswork. Generally, you know from correspondence what the problem is and going to be. And I don't think that one must assume that the question that you identified at the beginning as to the question that your expert must answer will stay that question. Questions may change and the focus may change, and it may branch out into other things, and the original question may fall away and something else may arise in its place. So one needs to have a fluid situation when it comes to what issues must the expert address. And the expert will be there to address whatever issues are useful to me as counsel. And the facts are my problem. I must get witnesses or documents to deal with the facts. But when it comes to the experts, I must be fluid as to what I need from my expert as the matter progresses.
Excellent. Duncan, you have any closing remarks?
Yeah, just one, which is that the problem which you identified often comes because lawyers appoint experts but don't manage them. And the expert takes on the role as problem solver and doesn't know the boundaries or the lanes within which the evidence is to be delivered. And it's one of the problems with, as Andre says, he likes to control his expert and have input. And a lot of our colleagues don't. Whether they may like to, but they don't actually do it. And so by the time you get to the hearing, the expert has decided what the pleadings mean. Sometimes they've decided what the law means. And they've bunged the whole lot in. And I mean, I think everybody in this room probably has read the potato board case in our case. But if you haven't read the potato board case, go and read the potato board case, because the Judge Wallace there sets out clearly what an expert shouldn't do, because in that case, that's what he did. He became the expert on everything, and he wrote a report where he answered every question. And then you've lost control of your expert and you've lost your case.
Svetlana, is this maybe a good opportunity if there is any urgent questions from the audience? We actually have a mic. If Garrett can figure out how it works, then we can take questions from the audience. Anyone? See, Garrett, you could have done that. You could.
Hello, everyone. My name is Tatishi Muloto from Pinson Basins. I'm an associate there. I have one question directed to Duncan. The question is, what approach do you adopt in instances where you have experts, be it delay or quantum, who have taken different approaches? Because this emanates from the method that I'm working on, where we've got delay experts that have used different methodologies. So you as an expert, to come to a decision, like what was the best approach that you follow in such instances? Thank you.
Thanks. Without getting into the weeds of delay and the different approaches, effectively, you're then in a 6 or nix situation. If one expert convinces you that his or her approach is the right one, you can't compare them because they've used different approaches, and then it's a 6 or nix. And so you're going to decide for one, and if the logic and science stacks up, that's the one that's going to succeed. Whereas if the experts have adopted similar approaches, they can be give and take along the way. So I think the simple answer is that's the consequence of having not paid heed to the other side's approach.
Thank you, Duncan. Well, in my experience, basically, with that precise issue, and now I'll give you a secret. We're doing a piece on that. People do not understand what in quantum terminology is figures as figures. Basically, there needs to be 3 prerequisites to compare the figures. It's the legal position, what you mentioned, methodology, and the facts. If you change any of the 3, the figures will be uncomparable. So then, in my experience, most of the tribunals, as Duncan said, will instruct at least quantum experts to do the figures as figures, basically a shopping list. Yeah, I think producing something equivalent in their delay is a bit more challenging, but if you do not do it, you risk your client's case in having the methodology that basically produces, if you like, an incorrect, on certain instances, a nonsense outcome. In which case, then Duncan will clearly decide in favor of your opponent. Thank you. I think we've got one more and then we'll move on.
Thank you.
We have one more. Okay.
All right, thank you very much. My name is Nkopani. Also a legal practitioner practicing as an attorney here in Ciarb. I have 2 questions, but I'm not too sure if one is too different from what my brother just put before the panel. I'm interested to know, what approach do you take as an arbitrator where you have 2 qualified experts given 2 opposing expert evidence? And when you look at the evidence, it looks compelling from both sides, but it's opposing views. So what tilts the scale as an arbitrator? That's the first question. And the second question is, just to go back to the example that was given, it's not sure by whom on the panel, but earlier there was an example given about where you would have a senior professor as an expert at a later stage and a junior professor, which you would employ or instruct at the beginning of the case. Case of that nature, where you employ a junior professor as an expert in your case at an initiation stage of your case, what is the credibility of the junior professor who's giving evidence to support your case from the beginning, as opposed to them being impartial and credible? How do you attach value to that, and how do you look into that? Thank you very much.
Thank you. Svetlana, we will discuss next time the 30 seconds rule. Okay. Duncan, please.
I missed the punchline of the first question. Let me answer the second question first. Let me make the point clear about the junior professor and the senior professor. The senior professor is the only one that gives evidence. The junior professor is a worker. They're part of your team preparing your claim. So the junior professor doesn't give evidence. Only the senior professor gives evidence. But you will have confidence that your claim will be supported by the senior professor because you had the junior professor in your team. So let me just make that clear. The first question related to the experts, then the arbitrator has a hard job, but you're going to do a proper analysis. You're going to assess, have they determined the facts? Have they both identified the right facts? Have the facts been proved? Have they applied the science correctly? Does the science make sense? And does the answer that they've produced flow from the facts and science that they've relied on? So I think that's, and very often the one becomes more compelling than the other.
Excellent answer, Duncan. I think we had one more from the gentleman. Yeah.
Gandhi Padel, advocate. I just want to find, Andre, you highlighted that you will pull in your expert early on. Then you file your claim and you discover that your opponent has got a weapon that you never anticipated. Are you going to go back to your report and then amend it or deal with the issues that have been raised by the opponent? How do you deal with such situations?
I think one must distinguish between when you engage your expert and consult with him or her, and when you file your report. When I say I want to engage my expert at the earliest opportunity, I mean I want the expert to advise me on what to do. But the report may not be written or finalized until after the pleadings have closed, after the factual witnesses have been, witness statements have been given, and close to the hearing. So there's no changing of report. You may change your methodology or direction of your case, or the way your claim is formulated as you become wiser as the case progresses. But I wouldn't be have the expert writing reports at the beginning. That will come at the end, and that will be the crystallized part of my case.
I think we're promised a short question and even the shortest answer.
Will be 10 seconds. Bongani Manenza from Group 621 as well. My question is for a head note. I'd say it's directed at conflict of interest, potential conflict of interest, where you get an expert involved in the mediation process, and they produce a report which you as counsel then use during that mediation. And then you find that that same expert then for the arbitration switches over to your opponents. I guess as counsel, do you support the suggestion by your attorneys that you must object to that expert presenting evidence at arbitration? And as an arbitrator, if you become aware of the fact that they were previously involved in the mediation and for the opposite side, how do you deal with that evidence? Do you think it's tainted in any way? So yeah.
I would have no hesitation saying that expert cannot act on the other side, because in any matter, you are opening up your heart to the expert. That expert knows everything about your case and your thinking and your problems, and then for the mediation, it's no less than for an arbitration. You're going to be spilling the beans to that expert. That expert cannot go to the other side and act. I would object. There's a clear conflict. In fact, the expert should never have taken the brief for the other side in the first place.
Thank you, Andrew. That was clear. So we'll move on to the question. You've got one more. Shall we do one, but quick one? But then I'll get to one reward question for you. You need to explain what's the memorials and what are the pleadings.
Yeah, good evening, everyone. My name is Lucky Namakonde. I'm a quantity surveyor by profession, but I also run a company which deals with claims. So mine is more of I want to tilt the scale a bit because it's advocate who's talking only. So the question there was, what can we do to make sure that the information is complete and it's accurate and it's helpful for the tribunal? And what I've seen is that in most expert reports that I have to do is the time. Expert takes all the time by themselves. The only time that they come to you is when you're left with two or 3 days to do the report. And also there's a tendency of hiding witness of facts, wherein when you have prepared your report and you're about to go to arbitration, you are sitting around the table, you find that there's another QS who has been involved on the project all along, but you're never introduced to that person. And I've experienced it not once, maybe even twice, where information is hidden. And I don't understand why, because it actually defeats the case of the client. So I think it's time to me. And also, if a witness of facts are there, we need to be exposed to them. Thanks.
Shall we have a quick answer about managing the facts or?
Yeah, I mean, I'm not sure there's really a question in there. It sounds like it's an ongoing problem that you have. And it's something that I've experienced before, I guess being brought in at the last minute, and then you have to consider whether you want to take it. Obviously with you trying to do a role for the arbitrator. So yeah, and also the concern in taking it is you want to be able to sit there and say you've considered all the facts, and there's this thing that keeps you up the night before you're going to give evidence. Is there's something you haven't read or a document that's out there, and if you say there's a body of work that's sitting there and may come put to you, then it's really going to not look that good for your analysis, and then potentially your credibility, and that sort of follows you around. So it's definitely a concern, and you try to avoid those situations as much as possible. Is all I can say.
I think this ties in nicely with the next question, and this is basically, are memorial style submissions more effective than pleadings? So I was asked that then to clarify, unless there are volunteers, what memorial means is that you file all of your basically facts and expert evidence along with your pleading, whereas in your traditional pleadings, you're going to have your pleaded case followed by the exchange of facts and proving the facts and proving your points by way of expert evidence. And I will really urge 70% of the lawyers not to respond depends, because just so that we get a bit more interesting debate about the issue. Garrett, when you see 40.
If I can clarify, ask a clarification question. When you say more effective, as in more effective in setting up the expert, or more effective as a strategy for winning the case? There are two different questions there. So what would you?
Pretty much in all terms, whether basically memorials produces a more effective process, be that a better evidence, be that faster, completeness, and the like. So it's an overarching a yes or no. We're there. Seems Duncan wins, yeah? And not surprisingly, he goes first to confirm that everybody are right in the room. Go on, Duncan.
Let me tell you why it depends.
Yeah.
The answer is yes for small matters. Memorial style pleadings are better. The answer is no for big matters. Because in a small matter where the dispute is precisely defined, and you have submissions and you can focus the debate, the memorial is perfect, because you're going to plead the case clearly. You're going to have the evidence. Everybody knows what has to be said. You say it, and you can do it all in one document. If you have a complex dispute, your memorial will be 5,000 pages, and 4,000 of it will never get read again. So you're in a complex dispute. Again, it goes back to what I said earlier. You need your pleading to identify the question as precisely as possible. People who plead in memorial pleadings never try to define the issue precisely. They just walk. And so complex disputes benefit from clarity from the very early on, and you achieve that with pleadings that you can then you plead your case, I plead mine. We work out what the real problems are, and then we can do the rest of them.
Excellent.
So it depends.
Thank you, Duncan. Andre, can you disagree with Duncan?
I agree with much of what he says, but can I perhaps just qualify? It is unhelpful generally to have court-style pleadings in matters of this type, because and I fully understand what Duncan says about very long, complex matters. But court-style pleadings, there are paragraphs, you did this, you didn't do this, you didn't, and then there's a bare denial. Tells you nothing. You can't identify the proper issues in the matter just from court-style pleadings. So I am in favor generally of memorial-style pleading. And as I say, I fully accept what Duncan says. The other point about memorial-style pleadings is that it depends on another thing, and that is the drafter. Because if you are one of the drafters that just tells a story from beginning to end, then Duncan's absolutely right. You will never know what the issues are in those papers. But if you're working to a structure, if you are addressing the issues in the matter, if you're addressing the particular problems, claims, defenses, whatever it is, and you're working to a structure as we teach the junior counsel to draft affidavits. You don't just tell a story. You address the elements of your claim or the elements of your defense, and you tell the story around a structure. So if the memorial style pleading is done properly, according to a structure, then it should be much better than court style pleadings to define the issues for the problems.
Excellent.
At an early stage.
Tim?
Yeah, I mean, I would err on the side from an expert perspective of more complete submissions. I think to use it's similar to the example you gave before around a common data set. Being able to, as an expert, hand on heart, say, hey, you're across all the documents and you've seen everything. And I think that would, in my opinion, swing the pendulum towards the having a complete, not a pleading situation. Yeah.
Thank you. I'll put my spin on it. In my view, it's basically yes, but they require effort. And I think all three of you basically discussed about the effort. And now, obviously, I think there are some experts in the room. What normally happens, you work with Andre and you've got a deadline and we got all the same deadline and you've got all the facts 5 minutes to midnight and you need to submit on a midnight. And you haven't been told the fact until you're submitting your expert delay, any sort of technical report. So meaning I've worked on some successful memorials and fully agree with you, Duncan. If you put effort and if you can at least overcome the hurdle of common data set, they can be very effective. But then if team produces an expert report based on one set of data because for one reason or another, his client didn't give him everything, and the opponent comes with something which crucially affects a team's work, first expert report of team basically goes out of the window. It's a useless effort. So I think if parties can come to that, basically, I think that there's some probably prerequisites to make it work, then it can work. But if the parties are very tactical about the facts, then it can cause a lot of problem. Duncan, you maybe want to say a few closing remarks on the memorials?
Well, I agree with that, but I think in the culture of South African litigation and arbitration, that sort of knee-jerk reaction to obfuscate is real, and so my experience is that people don't prepare memorials properly, and so I haven't had good experience with memorials in any matter that is bigger than one or two disputes. I think that's the reality.
Excellent. So it depends is the correct answer. Thank you so much, Duncan. We'll move on to the fifth question. This is, in your experience, do tribunals engage enough with experts ahead of any evidentiary hearing? So basically, we've got answers yes, no. Duncan's favorite answer, it depends. And there are some high-profile arbitrators in the room, so I will not answer. So here we're giving a bit more liberty in terms of what you can answer or not. think, Tim, we will accelerate in your language. So I think you will go first. It seems that you've got quite a clear picture what the audience thinks, but what do you think?
In my experience, it's very rare to have engagements with the tribunal at an early stage. And if at all, until you get to the hearing. My answer is no, which I think is the common answer there. But the concern is, and this is a point that I'm sure Andre is going to make now, and he made earlier, is that the parties and their counsel and attorneys don't exactly know the nub of the dispute yet, or what their case is, and so they're very reluctant. And I think you articulated that point quite early to set questions that the experts and lock in a position that the four walls what the experts are answering at a very early stage. And so I think there's potentially a valid reason there. But from a pure expert perspective, it'd be good to have some direction early on and sort of have that engagement to your ultimate the person that's going to consider your evidence as being the arbitration, being the tribunal. I think should be more often.
Thank you, Tim. Andre, please, your view and experience.
I think it's a very difficult idea that the experts should engage with the tribunal at an earlier stage. There are a few reasons why I have a problem with it. The first is that certainly in our jurisdiction, the tribunal is not steeped in the matter until you get to the hearing or close to the hearing. The tribunal doesn't know what the matter is about, other than vague pleadings, perhaps some witness statements, but is not steeped in the matter. The idea that the expert should not go to the tribunal and say, we have a disagreement, and just take an example. There's a ton of documents here. We want to take a sample of documents. What sample can we take? 10%, 5%, 1%? And the tribunal then hypothetically says, take 5%. Get to the hearing, and now there's a debate. Was 5% enough or not? It wasn't. The tribunal's made a decision with limited knowledge, cold, and so to speak, and the decision may be wrong. Secondly, whenever the experts go to the tribunal and say we want direction on something, I want to be present as counsel. I'm not going to have my experts talk to the tribunal and get directions without any input from me as counsel, from the legal team. It doesn't have to be counsel, it could be attorneys who run the matter. So I think it's a big problem, and the problem is simply that we're not dealing with an adjudication type of situation where you can have an inquisitorial system and you can start to get engaged with the parties at an early stage. And arbitration is, certainly in this division, very much judicial system, process that needs to have both parties heard. And all you're doing, I think, is chasing up costs. What I do think is valuable is that the experts meet with each other at earlier stage as possible. Even before they file reports, they can talk to each other and get a feel for where are they, don't they see eye to eye. And then, of course, hot tubbing is very valuable, but by that time, you have all the pleadings, you have all the facts, you've got all the reports, and it's part of the evidentiary process to have a hot tubbing session, which I think is a very valuable thing to do, should be done, but it's not at an early stage. So I have a problem as counsel to say that we don't engage, the tribunal doesn't engage early enough with the expert. I think what we're doing is probably the right thing from my point of view as counsel.
Thank you, Andre. And I think Duncan, Andre insinuated that arbitrators in South Africa do not read the case, meaning I don't believe that he referred to you, but
No,
you know.
he said they read because they charge for reading.
Yeah.
They just don't understand it.
Well taken. Excellent. Now you need to expand on the topic.
Yeah, I must say, I'm big on this. I think an arbitrator does no one any favors by getting into the arena. And if you go in and talk to experts before you've heard evidence, you're getting into the arena. There may be types of matters where all the facts are common cause. Everybody's got a clear idea of precisely what the problem is. And it's just a technical question, almost a theoretical technical question that experts are dealing with. Then you can have theoretically, you could have an informal engagement to let the arbitrator understand what he's dealing with. But I mean, even then, I'd rather do that in an open forum. So I don't think there's scope, certainly not with the lawyers in our country. I don't think there's scope for sort of doing anything by an arbitrator outside of the formal forum.
Excellent. Tim, you wanted to add something?
Yeah, I was just going to summarize. It sounds like trust issues.
Indeed. Let me meaning I do a lot of work in Africa, but even more so in the Middle East. It seems that the tides are changing because there are a lot of tribunals that get disappointed with the evidence that they receive eventually. They can't determine the case. And it seems that now that they're becoming more and more, if even like paranoid that this will happen. And now there are a lot of, if you like, high profile arbitrators that put quite prescriptive instructions to arbitrators, but in broad terms, Duncan, not going to substance, Andre, right? So basically they instruct them what they expect from an expert to do, because the world of international arbitration is such that people come from varying backgrounds and they've got some personal ideas what they believe the tribunal needs. And basically what this question was about is whether do you think it's appropriate that at any point in time, again, I'm not talking about substance. Substance can come basically when the sampling is costly. Sometimes that issue arises, but would you consider perhaps, Duncan, to have such sort, meaning if you've got a high profile case, you've got thousands and you're expecting thousands of documents on a construction case, and you're simply concerned by even reading the preliminary request for arbitration, it's going to be very messy. Will you consider to give some at least high-level prescriptions in terms of what you expect the experts to produce?
Igor, I think I would be very nervous to do it before they had produced something. I don't think I would engage before they had produced something. But I can see a benefit in reading a report or reading competing reports, perhaps reading the first expert minute in Scott's schedule and saying they've missed it here. And then perhaps giving a set of questions, specific questions, saying I'd like both experts to be more specific about how we deal with these items, or could you arrange your Scott schedule in these themes, or could you do that type of thing? So I can see the benefit of an engagement from an arbitrator then, but I would be completely averse to getting involved before they've produced something.
Excellent. Andre, you have something to add?
Yes, let me just add this, that where an arbitrator can be useful in this context is obviously specifying time periods for things to be done. Engaging with the parties at an early stage as to what questions should be answered by the experts, and perhaps giving some directions as to the format of the report. For instance, I want your report to be in tabular form, where you deal with these questions and answer this question, put in tabular form so that your counterpart can fill in the other column and answer, so that the questions are answered and directly comparable. So yes, the arbitrator can, for certain, assist in that regard.
Excellent.
But very difficult to go into more detail than that and give any kind of directions or decisions.
Yeah. That's precisely, meaning I've been recently appointed on a matter in the Middle East. We received 24 pages instructions, what the, I think it's an overkill, but anyway, meaning they're very prescriptive and meaning you know, it's a world of mouth, and meaning you know who the arbitrators are, and pretty much you know what happened in some of the high-profile cases. And it's precisely that. They couldn't determine the case, Andre, and they become very nervous. They want to make the use of an expert, but then, Tim, what you and I discussed, then the parties become very nervous that this is guiding them perhaps too much. And I think, as you, Duncan, mentioned, finding the right balance, that you get the evidence that you need without basically affecting the party's autonomy to present the case that they best feel fits. Meaning, maybe you want to fight the facts. Maybe you want your expert to be unhelpful. Yeah. But meaning the arbitrators are more and more concerned in high-profile engineering matters that they can use the evidence. Let's move on to the last question of the night. And hopefully we can keep it fairly brief. Again, you can type whatever you like on the topic. And that is, if there was, again, one thing in particular that counsel, expert, arbitrator could do to ensure better expert evidence. And probably we heard quite a lot of ideas during this evening. What will it be? I think now at the last question, the audience gets that, you know, you can throw something like this important point of paying more, which we kind of think it's equally applies to counsel, arbitrator, and experts. It's a fair point. Thank you, Andre. Andre, being mindful that this is the last thing that is preventing audience from enjoying some refreshments, perhaps if you can make one thing in particular that you think that we can do things better in terms of the effectiveness of the expert evidence.
I want to get the best expert I can. And that includes, as I said earlier, the ability to articulate what the opinion is and the reasons. And if I could just add this, one way of getting the best expert is to say to your expert, who do you go to if you've got a problem? I go to so-and-so, I take advice from so-and-so. And then you ask that person, who do you go to? Ultimately, you get to the pinnacle. You've got the best expert, and that's what you want.
That's a fair point. Tim?
Yeah, I would say, coming from the expert perspective, that it's that willingness at the joint report, the Scott schedule stage, to really produce something, not dig your heels in on your report and go into defense mode and avoid dealing with any hypothetical or adopting assumptions from the other side, which would then actually provide a document that's useful and aids the process. So it's that sort of willingness, especially, as you said, 5 minutes to midnight, to just, yes, your report still stands, but if you want to look at the situation from the way that my opposing expert has, then this is the other issues which may arise, or you perhaps should even accept his opinion on if it turns on that issue. So yeah, I'd say the word, that willingness to be, and that open-mindedness right to the end.
Excellent. Thank you, Tim. And last but not the least, Duncan.
I'll go back to my formulation, the decision tree question. And just to take something up that you said earlier, Igor, you referred to, you know, determining what the issue is. And I'd encourage people to look beyond the issue. You formulate the issue, but the issue is a heading. Go and work out what the questions are and the sub-questions are in determining the issues, because that's where people don't do the work. And you need to write it out as a heading, question 1, question 2, question sub-question 1.2, and then answer each one. And if both experts and the lawyers focus on doing that, you'll get proper dispute resolution.
Spot on, Dan. My view is exactly the same. Basically, the good use of joint reports and statements, they need to be clear. They need to have the issues that we discuss, and they need to enable the arbitrator to navigate through the decision-making progress. Again, Tim, back to the point, what is a fact, what is the opinion, and basically what the role of the experts is to basically enable Duncan and his colleagues to reach a fair outcome of the arbitration proceedings. Duncan, just as a closing remark, will you agree that, you know, a good joint statement, good joint report, because it's a different, right? Meaning report sets out, you know, in the appendices why they disagree to a kind of lengthier format. Will you use a good joint, like a Scott schedule type of format as a main tool after the hearing?
Yes.
Again, I'm repeating good one, not meaning if you get
No,
a useless one, then obviously, yeah.
The of good expert report and good heads of argument from the lawyers. Yeah. That's the key, because you've got the facts that have been clearly recorded, you've got the opinions and where they differ.
Yeah.
And then you've got the lawyer's submissions as to why the one is better than the other. And those two documents, if they're prepared properly, would be are critical and properly cross-referenced.
Excellent. On that bright note, we're basically reaching the end of our session for today. So thank you very much. And please join us for some refreshments and a bit more difficult offline discussions with the panel. Thank you so much.
Yes, if I may remind everyone to check with the link that is outside on the attendance list. Thank you very much.